Well, when going through a divorce, it can be hard to handle the stress and emotional turmoil, and arguments over child custody can only complicate the situation further. It's important to remember that your actions, both during and outside of legal proceedings, can actually put you at a huge disadvantage in court. Here are some common mistakes people make, as divorce lawyer Tanya Davies. Tanya, good morning. Thanks for joining us.
Good morning, Annette.
All right, let's talk about a few scenarios here and break it down as to how or what people should be doing in these cases. Inappropriate, offensive, and bullying text messages and emails to the other parent. I would imagine this happens in the lead up to a separation or perhaps through the process, but can really come back to bite you, can it?
Yes, it is very unfortunate, Annette, and we see a lot of scenarios like this in court where judges frown upon, especially if you're seeking a joint custody arrangement, but you cannot even communicate respectfully with the other parent. Offensive language, bullying in the form of an email or a text message is admissible evidence in court. And of course, if this is what is presented, you can forget about a joint parenting arrangement. I always advise clients, if you wish to communicate in a written format with the other parent, use our family wizard. It's an application online, and it actually corrects your language. If you state something inappropriate or offensive, the program does not allow you to send the message and asks you to use a different sentence.
So, I mean, that's got to be pretty tough for parents, because once it's sent, it's sent. And if that other parent uses that against you, that could determine the outcome of how the judge decides for who gets the custody. Is that right? Like they're using it as a means to get custody of the child?
No. So whenever parents are not even aware of the impact that it actually has in court. But if you're seeking a joint custody parenting arrangement, the law states that the parents need to be able to communicate. And of course, if the communication goes sour, if you cannot respect the other parent, and if that evidence is presented in court, you would not be in a position, or in a good position, I should say, to obtain a joint custody parenting arrangement.
How detrimental can saying negative things to the child about the other parent and passing messages through the child to the other parent be?
It is very detrimental as well, because if we appoint the office of the children's lawyer, for example, all of this information comes out that there are many derogatory messages about the other parent to the child. And of course, it's completely inappropriate. It damages the child psychologically and emotionally. And in a scenario like this, you can forget about the joint parenting arrangement as well. What I've seen my own clients do, and of course you tell them that it's a no-no, is pass checks, for example, for child and spousal support through the child. It's also very inappropriate and frowned upon when you involve your child in adult conflict.
Can that even haunt you later on down the road, after a couple has separated, that if one is speaking poorly about the other parent to that child or through that child, can that be used later on down the road, even not only during the time of separation, but even years later, that can come back and that one parent can use that in court?
Yeah, so for example, when there is already a final order for joint custody, for example, and then the parents relax at that point because the order is already made, and start using derogatory language, you present it as evidence, or using your child essentially as a pawn, making negative remarks to the child about the other parent. One of the parents can even bring a motion to change the final order based on a material change in circumstances, and that would certainly be a material change that would affect the child negatively.
Wow. All right, let's talk about something that is even far more serious, and that's fabricating allegations of abuse in order to gain an advantage in litigation. Does this happen very often?
Well, I wouldn't say very often on that, but unfortunately it does happen. In my own case, for example, that we just argued recently, a judge even went as far as reversing primary residence of the child, because the judge, and normally it happens at a very final stage, which is a trial. But in this circumstance, the parental alienation the judge found was so severe, based on fabricated allegations to the police and to CES, that they reversed primary residence of the child.
If allegations like this are made, would police automatically be involved in order to conduct an investigation to prove otherwise?
They would, but in order to charge the person that you're making allegations against. But of course, the police would have to find reasonable and probable grounds in order to charge that person. and if that evidence does not exist, where they essentially feel that it's fabricated, this is where, when the other side would request a police report, this is what the report would state. And of course, it would be used against the parent making up that allegation in court.
All right, great information as always. Tanya Davies from Davies Law, thank you so much for your time today.
Thank you, Annette.